June 7th through the 11th, 1942, the American Navy put a significant defeat upon the Japanese Navy, a superior Japanese force. Walter Lord wrote a book about this in the 70s called Incredible Victory. The story you're about to hear is almost that good. So we're going to talk about three projects that were linked together. State Highway 45 Southwest, the Loop 1 MoPac intersections, which I will just shorthand call the intersections, and the MoPac managed lanes projects. So a little bit of background. State Highway 45 has been around since the 80s in Austin, and all these projects are in Austin, and I'll talk a little bit about where they're located here in a second. State Highway 45 has been around since the 1980s, and State Highway 45 Segment 3, which is almost directly analogous to the piece I'm going to talk about today, State Highway 45 Southwest, was sued by the same plaintiffs we're going to discuss in 1989 for almost exactly the same issue. And in that case, the Federal Highway Administration and TxDOT were sued, and in that instance, we prevailed. In 2013, CTRMA, the Central Texas Mobility Authority, and TxDOT jointly started working on the State Highway 45 Southwest project. The Loop 1 intersections project is basically two grade separations on Loop 1, and that's a project that was being developed by the Austin District. And the Loop 1 managed lane project is another project that's being developed by Central Texas Mobility Authority, and that was looking at putting a managed lane on MoPac south of the Colorado River. In February of 2016, TxDOT was sued by the Miss Fath, and so you'll see this case often referred to in the literature as Fath versus TxDOT, and the Barton Creek Association, and a whole cast of other characters, including Jerry Jeff Walker and Carol Keaton Rylander, I think is her name at this point. And so in February 2016, they filed suit against TxDOT. At that time, we had completed a state EIS on State Highway 45 Southwest, state EIS, a federal EA on the intersections project, and the MoPac managed lane study was still underway, and they were in the process of preparing a federal EA. So there were 4 claims, and I'll go through each claim, but let me tell you just briefly how the lawsuit went down. There was a preliminary injunction hearing, and in the preliminary injunction hearing, basically what happens there is both sides come and present their arguments that they would ultimately present in court should the case end up going to court, going to trial. And the standard of judicial review is that the plaintiffs have to demonstrate a substantial likelihood that they would succeed on the merits of their case. And so, in essence, we were trying the State Highway 45 project at that point. I should say, let me back up and mention one thing. State Highway 45 MoPac runs north-south through Austin. State Highway 45 is going to connect the very southern tip of MoPac to FM 1626. So we got MoPac here, 1626 here, and then about, a half a mile north of where that connection point is where the two intersections projects are, these two grade separations. And then north of that, the managed lane was going to continue on up to the Colorado River. So all these projects are closely related to, or closely geographically located towards each other. So we went to a court. We had a preliminary hearing, preliminary injunction hearing. The district court denied the plaintiff's motion. Basically, we presented our case, they presented their case, and the court thought that the plaintiffs did not have a substantial likelihood of succeeding on the merits of their case. The plaintiffs appealed that to the Fifth Circuit. In New Orleans, the Fifth Circuit also agreed that they did not have a substantial likelihood of winning on the merits of their case. However, that doesn't mean you can't just go to trial. You have that option as a plaintiff. And so we ended up actually having a trial where both sides once again presented their arguments, And the district court, again, decided in TxDOT's favor. That was appealed to the Fifth Circuit, and it is currently on appeal. So there's more to come on that. We're cautiously optimistic that the Fifth Circuit will look at the same information they looked at last time and reach the same conclusion, but you never know. So let me talk about the 4 claims. So the first claim was that TxDOT and CTRMA violated NEPA and the Administrative Procedures Act by embarking on 3 projects. Remember, we have the 3 projects. We have Loop 1, Managed Lanes, MoPac intersections, and State Highway 45 Southwest, without preparing a single environmental impact statement that evaluated the impacts of the alternatives for all 3 projects collectively in a single document. So if you recall, we did a state EIS, a federal EA, and we hadn't finished the federal EA on the MoPac managed lanes. So that was the first claim. So segmentation, as you all know, is a big deal in NEPA type suits. And so what the court really starts to look at there is, are these standalone projects? And all of you, I think, are familiar with the term independent utility. Can the project exist in and of itself without the other projects being attached to it? And so the court looked at the various segmentation factors that they're required to look at, and they held that the intersections was a standalone project, that it had logical termini, that it had independent utility, and that it need not be considered with these other projects. Loop 1 managed lanes, since there was no decision on that at the time, there was no NEPA decision, it was not subject to the Administrative Procedures Act, and so it was kind of tossed out. So really the argument came down to whether the intersections and State Highway 45 should have been evaluated at the same time. And the court held that no, they were both independent projects, they had independent utility, and they need not be looked at the same time. So that was the first claim. The second claim was an interesting way to try and federalize State Highway 45. So as you guys know, when we get challenged on a federal project, we're challenged under the Administrative Procedures Act, which basically says, you know, state, or did you follow the federal procedure in clearing this project? But State Highway 45 Southwest, if you recall, was a state EIS. So it was cleared under the state's rules. So that project was not challengeable under the Administrative Procedures Act. And so the plaintiffs made the claim 2, that TxDOT violated NEPA and the Administrative Procedures Act by failing to perform an environmental study of the State Highway 45 Southwest project under NEPA, because the plaintiffs maintained that State Highway 45 Southwest was subject to regulation and approval by the United States Fish and Wildlife Service. So they were saying, you know, that this is a federal project because you're going to have to get approval from the U.S. Fish and Wildlife Service. And the court in that instance, let me say, there's 2 types of interaction that TxDOT can have with U.S. Fish and Wildlife. One of them is under the Section 7 portion of the Endangered Species Act, where we consult with the service about what we're doing, and we come to some agreement about what the potential impacts are and what maybe mitigation measures we might do. There's also Section 10, which is a strictly voluntary program that a state action could consult with the Fish and Wildlife on. But that strictly voluntary is the important part of that. So again, the court in this case found that the requirement for TxDOT to consult with the U.S. Fish and Wildlife Service didn't bestow federal control and responsibility on the Fish and Wildlife Service for State Highway 45, because the Section 10 process is entirely voluntary. It was entirely up to our judgment as to whether we wanted to consult with the service or not. And in this instance, we did not consult with the service. Claim 3 had to do with indirect and cumulative impacts, and this also is an area that I think you all are familiar with, that we often get challenged on our environmental projects. The claim in this case was specifically for the intersections only, and it claimed that we had violated NEPA because we failed to adequately address cumulative impacts, and TxDOT's approval of the intersections project was arbitrary and capricious, and thereby a violation of the Administrative Procedures Act. And so in this instance, it was very important that we had a good administrative record, and I'll talk about that at the end. Basically, the court found in that case is because the intersections EA adequately analyzed the potential cumulative impacts and impacts to groundwater quality, groundwater was a big issue, and that the administrative record fully supported that analysis, there was no way the court could look at the decision the department made as being arbitrary or capricious or an abuse of discretion or any of that nature. The record showed that we took due consideration of the potential impacts to those cumulative impacts and to those species. The final claim had to do with a potential noise impact. The plaintiffs claimed that the intersection projects would produce noise that would constitute a constructive use of the Lady Bird Johnson Wildflower Center in violation of Section 4F. And again, the court found that TxDOT had properly used FHWA's noise modeling criteria to determine at 3 locations that noise levels would exceed the federal criteria on the Wildflower Center. We, of course, when we do that, as you all know, if we are going to exceed noise levels, we'll propose noise walls. We'll offer noise walls to consideration. In this case, the Wildflower Center declined. They did not want those noise walls. The court disagreed with the plaintiff's contention that TxDOT did not use proper noise methodology and that TxDOT should have found a use of the Wildflower Center. So basically, the court did not find their argument compelling. And the court went on to say that TxDOT is not required to document each determination of a project that would not result in an impact or in a constructive use. Instead, the burden falls upon the plaintiffs to show how the action would result in a use. So basically, we don't have to prove a negative when we're working on our projects. Now, you would think that would be the end of it. But as Steve Martin once said, no, that was not the end of it. So as I said, it's still over at the Fifth Circuit. We're waiting to hear about that. But in the meantime, the Save Barton Creek Association and the Center for Biological Diversity out of Arizona filed another lawsuit on the Intersections Project. And this time the suit claimed that the department was required to consult with the Fish and Wildlife Service, and we did not do so. And so what do you think we did? We consulted with the Fish and Wildlife Service. So we decided, well, we would consult with the Fish and Wildlife Service. That was what everybody was upset about. We would consult with them, and we did consult with the Fish and Wildlife Service, and that consultation resulted in an 11-page letter from the service basically saying that they concurred with our reasoning that any impacts to groundwater quality and potentially the Barton Springs salamander were negligible and discountable, and the project need not consult any further. So again, you would think that would be the end of it, but it was not. The Center for Biological Diversity and the Save Barton Springs folks amended their complaint to include the Fish and Wildlife Service, and basically contended that the Fish and Wildlife Service had abused their discretion and they were acting in an arbitrary and capricious manner. It's difficult for me to see how that's going to fly with the court. This is set to go in November, is that right? Yeah, November, we're supposed to see the court on this. We have an 11-page letter from the Fish and Wildlife Service. It was hardly arbitrary or capricious, so I don't see how far this one's going to go, but we'll find out. So finally, just a couple lessons learned from this. On the State Highway 45 Southwest project, because we had been sued on that project before, we knew we were going to get sued this time. And so we went to great pains to make sure our administrative record was well kept, that a lot of the information was contained in technical documents, and we made a valiant effort not to communicate too much by email. Now, with that said, we still had 50 boxes of emails that our diligent outside counsel and inside counsel in the Attorney General's office had to go through and ferret out and decide. I think there was about 13 out of those 50 boxes of emails that we ultimately ended up including in the administrative record. But we made a good effort. It could have been 100 boxes. So the other thing that I'll note is we did not expect to be sued on the intersections. Just for dumb luck, the intersections almost was a CE. It was almost a CE. Had the Austin District been maintaining the right-of-way out there, it might have been a CE. We still may have consulted with the service, but it could have been a categorical exclusion. But to the credit of the consultants that worked on that and the Austin District staff, that administrative record was in good shape. And the court was able to see what had gone on with that project and was ultimately able to conclude, based on what was kept in that record, that the department did not act arbitrarily and capriciously with regard to the cumulative impact analyses. A couple final things I'll say is it's exceptionally important when we write our purpose and needs for these projects. When you're in court and you see the purpose and need up on the screen with sections of it highlighted, and the court is pointing to these things that we've written, it really hammers that point home that it is very important that we think carefully about it. That's a very simple statement in most documents, but it can have dramatic implications later on down the line. The second thing had to do with explaining the logical termini. There was some question about what is the logical termini on an intersection project. And that question kind of came up, and the court, I think, at one point said, this time speaking to independent utility, I think the court said something to the effect, even I, the judge, can see that an intersections project where people no longer have to stop at a stoplight and people can walk over a sidewalk to go to their school has independent utility. In other words, it exists on its own. It doesn't need these other projects. In the case of the logical termini, in that instance, the logical termini were where the engineering staff determined it was necessary, whatever distance they felt away from the actual construction project, to tie back into the existing highway facility. So we didn't have to have an arbitrary, like the next road junction or something of that nature. It was just simply, that's where the engineers felt like it made sense to tie back in. Therefore, that was the logical termini. The final thing I'll say is that the technical analyses on both these projects were rigorous and well done and well documented. And that proved, I think, one of the key points in allowing the court to decide in our favor, because it was very, very well documented that we had taken an extremely hard look at the endangered species issues on both projects. It was there in the file, it was there in the record, and the court had no problem finding it, and we had no problem pointing to those files in the record and saying this is where it was. So this was TxDOT's first lawsuit flying on their own, if you will, with NEPA assignment. And we're, again, still cautiously optimistic that the Fifth Circuit will, again, look at the same information they've looked at before and arrive at the same conclusion, but that remains to be seen. And then we still have the one lawsuit that will find out what happens in November. So, are there any questions about that? That was a lot of stuff. Okay. What? Yeah. No, don't say that. Yes.
Just out of curiosity, have you told them the cost associated with all the lawsuits and how much that's added to?
The question is, have we totaled the cost associated with the lawsuit? I don't think we have. I mean, there's a lot of costs in there. There's the cost of our outside counsel, which we had two outside counsels, I believe, on this. Also, I should say that CTRMA shared the cost. Their counsel did a lot of the work. They had their own set of attorneys, and so it was our counsel, CTRMA's counsel, and of course, when TxDOT is being sued, the Attorney General's office represents us, and so the Attorney General's office was also involved. And then just in terms of staff time, there was some staff time involved in assembling the record. In the projects, the records were all complete. One project had a really efficient index, and the other project had a less efficient index, but everything was there. Everything was in the file. So, but I don't know what the cost would be. I'm sure it was not a minuscule expense. So, another question? Yes, sir. Okay, since 45 was a state project, it wasn't subject to 139L, which is the limitation on claims in the, is it FAST Act? FAST Act? FAST Act, yeah, the limitation on claims. In the case of the intersections, I believe we cleared it, and almost immediately they filed the suit. Is that correct? Yeah. So even had we filed the 139L, and I don't know if we had, they got in, well before the limitation was run out. So I think they knew that.
There was a restart on 39 for the service council.
There was a restart of the 139. That's right. Yeah, for the second lawsuit. So, because we had a consultation with the service and we felt like that opened the NEPA process again, so we did a new 139L. Yes, sir?
Doug, any follow-up on draft documents in the administrative record?
Okay, what Rob is referring to there is one of the strange statements from the court had to do with, there was some debate about whether draft documents could be included in the record. And the state and federal highways contention has always been that draft documents are not appropriate in the record. It is unclear what the court meant when they said draft documents can be in the record. Because you can look at it two ways. It's routine for us to have a draft environmental impact statement or a draft EA. Well, those are in the record because those are decision documents that we're going out to the public with, and they're called draft documents. But they're not draft in the sense of that they're a work in progress, that we're working on and something's going on. So at this point, we don't know, to tell you the truth. To me, having the draft documents in the record is inconvenient. But ultimately, when it comes down to the environmental decision, and Carlos, in this case, is signing the document, if the court says, Carlos, what documents did you rely upon to make your decision? Well, that is the draft EA that was circulated to the public and the final EA that was shown to the public. It doesn't matter how many draft versions of it we had beforehand, those were not decision documents. And so, although they would be inconvenient and they might show a little bit more of the thought process, I don't think from a legal perspective they could be, relied upon and say, well, you said this in the draft document. Well, yeah, I might have said that in the draft document, but that doesn't matter because the decision maker used these two documents and these technical reports to make their decision. So that's kind of how we're looking at it right now. It remains to be seen what the court will have to say about it. Any other questions?
What is the end game of the lawsuit? Two of the three projects are under construction currently, correct?
That is correct.
So if the lawsuit were to, if they were to win, what would be the end result?
Man, if I knew the answer to that, I would, not be standing up here. I'd be, like in Vegas gambling right now. Nobody knows. We think when they started, the idea was to stop State Highway 45 Southwest. Right now, State Highway 45 Southwest is probably nearing 50% completion. You think, Carlos? Probably about 50% completion. The intersections project has let, and they're starting to do utility relocations at this point. But the plaintiffs have a long history of just opposing anything that is south of the river in Travis County. And so their motivations are their own. At this point, both projects are proceeding forward, and until we hear something different from the court, that is how we'll act. And if we do hear something different from the court, well, we'll change what we're doing. So, any other questions? Can't see everybody up there, so. Okay, thank you.